stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome to Administrative Static. I'm John Vecchione, and I'm here with Mark Chenoweth. And we have what I won't call an unprecedented case because there's precedent, but a very unusual case to discuss today, having to do with Article 3 and how long judges can stay in their positions, and a ruckus that has emerged when one judge is trying to defenestrate another. And here to talk about it is Greg Dolin. Greg, welcome to the program. Tell us what's going on.
Thanks. Good. Thanks for having me back. It's good to be here. There is a court in D.C. It's an unusual court. It's a court of appeals, but unlike most other courts whose jurisdiction is limited geographically, this is a nationwide court that deals with patent issues, some veterans affairs issues, etc. So
the federal circuit.
The federal circuit.
And so the federal circuit, how many active judges are there on there? Federal circuit?
I think it has a full complement right now. So I think it's authorized 12 judgeships. So I think it's fully staffed, as well as there's a 5 or so, I think. I haven't looked recently, senior judges on it as well.
And what happened?
Well, there's a longest serving judge there. And in the interest of full disclosure, it's my judge. I clerked for her. Pauline Newman. She was appointed by President Ronald Reagan back in 1984. Interesting footnote. She was actually the first judge appointed directly to the federal circuit because the court did not exist until 82. And the first complement of judges were actually raised up from other courts, but she's the first one to be appointed there. She has been on this court for almost 40 years, and she has been became a legend in her own right. She's a very strong defender of patent rights and property. And, now there's a new chief judge on this court, Judge Kimberly A, appointed by President George W. Bush. And apparently there's some conflict where Judge Moore ultimately resulted in Judge Moore accusing Judge Newman of being either physically or mentally or both incapable of carrying out her duties. And as a result, she's seeking to force Judge Newman to retire. And in the meantime, in order to do that, to put the pressure on, bar Judge Newman from sitting as an active judge, from hearing cases, from having a full complement of staff the judge is authorized for. Also, so as you said, there's precedent for judicial investigations. I have not seen precedent for judges being taken away, being barred from their own office.
Right, and so and just to be clear about this, so the chief judge there took away her secretary.
Correct.
And she had, how many clerks do you get there?
So she has 4 clerks, just like every other.
Just like everyone else, right?
Just like everybody else.
And how many are allowed to be with her now?
It's a little complicated, but I think right now she has 3. One of them has voluntarily resigned, which, sometimes happens. Sometimes you don't necessarily fit with the judge, or the judge doesn't fit with you. Or in this case, was a lot of drama, and this clerk wanted to leave. But usually when that happens, judge is able to hire a replacement.
Right.
And it's not hard. If you're a federal judge, it's not hard to find some recent graduate to willing to work for you. But Judge Newman is not being permitted to hire a replacement.
Half-life of judicial clerk vacancies has to be among the shortest half-lives of all jobs in America, I would think.
I filled one myself long ago. So the Judge Moore starts doing this to Judge Newman, and then what does she do after that? Like, does she do this in a vacuum, or what does she file or do, or what happens?
Well, so Judge Moore filed. So there's an interesting procedure. Traditionally, complaints against judges are brought by outsiders. Somebody says, I saw a judge take a bribe, or I saw a judge yell at some, or whatever it is, right? So it's by outsiders saying judge behaved in an appropriate manner.
Right.
And that goes to the chief judge. And if chief judge says well, that sounds like, nonsense, it's immediately dismissed. If it sounds something like more than nonsense, chief judge appoints an investigative committee and starts looking at it. Here, there was no outsider. Here, Judge Moore was herself essentially the complainant, and that is a procedure authorized by the rules. But then she also is a witness because she says, like, I saw Judge Newman not being up to snuff. And therefore, I'm complaining about Judge Newman about being not up to snuff. And now I'm going to investigate Judge Newman about being not up to snuff and ultimately make a decision about it.
About my credibility as a witness.
Exactly.
and about the facts and everything. I mean, it really is outrageous. And I think that all the commentators I've seen are like, wait a minute,
without exception,
there's this principle that you can't be the judge in your own case. Right. And so, and I think even lay people know that.
Well,
right.
But even, especially courts of appeals they're meant to be collegial bodies. So when there's an investigation against a judge, initially, if it's done properly, you never know how it's going to come out. And ultimately, these people, if a judge, for example, is cleared, they have to work together. And even if somebody's cleared, it might leave a bad taste in somebody's mouth. So traditionally, it has been a procedure where the chief judge of the given circuit, even when there's something there, would ask judges of another circuit to investigate. So recently there was a case about a judge on a Sixth Circuit. There were some allegations that he sought reimbursement for certain travels that he was not supposed to have been seeking. So there's just some serious financial improprieties.
A former chief judge
of that circuit. Yeah. And even there...
Boy, smart in there. I mean, this is all public, so I don't feel like we need to hide his name.
So, but in any event, so there where it's just all basically documents. How much did you spend? What receipts you sent to the government? It was not personality based. Even there, the Sixth Circuit asked a different court to investigate. Well, it's not about credibility. And so here, the fact that Judge Moore has not yet asked for that to happen raises some serious questions.
Right. And so what do we do?
Well, like I said, Judge Newman is my former judge. I clerked for her. And so when all of this started, she reached out to me together with some of her other former clerks because I was not initially. So all of these procedures are initially done in secret. And so I was not aware until the judge herself disclosed it to us. And fortunately, New Civil Liberties Alliance got involved. So she's now our client. And for now, we sought the remedy of the very least of two things. One, to get this matter transferred to another circuit where the judges who are more removed from the kind of daily turmoil in the circuit can actually take a look at it and more neutral. And number two, which is, I don't know which one is actually more important, is to follow the Constitution. Circuit Judge Newman was appointed by the president, was confirmed by the Senate, and has a right to hold the office during good behavior. And it's not just her right; it's the right of the public.
And it's issuing opinions, right?
And issuing opinions, right? And so, but it's the right of the public to have their case adjudicated not by some handpicked, selection of judges, but by the full complement of judges that the president sought appropriate to nominate, the Senate sought appropriate to confirm. So we asked Chief Judge Moore, and we copied Chief Justice Roberts on this letter to restore Judge Newman to actual active status and not just active status in name only.
And Mark, you were involved in this case. I ask, so what is the principle? What is the NCLA principle here that we're aiming at? Well, and I mentioned Article 3 to start.
Sure. Well, I think it's due process as well. I mean, I think that we, and it's funny that when I mentioned this, I was at the Heritage 50th Anniversary Gala at the end of last week, and a couple of people had seen the letter that went to Chief Judge Moore, and it said, congratulations on getting involved in this and that kind of thing. And then they'd say, well, why are you guys getting involved? And I said, well, due process. I mean, they're penalizing her before they have actually done any of the adjudication to decide whether or not these charges are accurate. And then I said that to 2 or 3 people, and the instant response was, "Oh, of course, that makes perfect sense for you guys." And I think it does.
But just to add, there's also serious questions. So Mark mentioned that there's penalty before adjudication, but there's some serious questions whether or not even after adjudication, the judiciary can remove one of its own.
Right.
That is exactly, and I want to get to that point, Greg. If the Constitution says that after you're appointed and confirmed by the Senate as a judge, you serve for life for good behavior, right? And good behavior is usually you get impeached. I know that's the way they usually get rid of judges. And you mentioned they're like pressuring her to resign. This is like a pressure to resign. And so the things they've done to take away her ability to write opinions and do anything, because you take away staff, that's what happens, right?
Right.
So this is all a pressure campaign before she's had any due process, and all of it done by the person who's the accuser and the adjudicator. It's really amazing.
And the person responsible for making sure that everything runs appropriately in that circuit.
Right. No, that's exactly right. And I was talking to one of our colleagues, and he pointed out that obviously the judges are not the only people who might have health issues, and the presidents might have health issues. And this is without going into any personalities. But when we as a country realized that might happen, we passed the 25th Amendment saying there's now going to, because before the only way to remove the president was through impeachment. We realized that, well, that might take too long, and we might, we have nuclear weapons now, we need to do things. And so we have a whole process for it. Well, if we needed a whole constitutional amendment to do this to the president, maybe it's a good idea to have judges investigate judges. Maybe yes, maybe no. But the point is, we can't do it by statute. We need to do the same constitutional process as we did.
Because the Constitution says impeachment.
Exactly.
And if you want to change that, you have to amend the Constitution.
Right. Whether it's a good idea or bad idea, that's for perhaps a different podcast. But the point is, good idea or bad idea, it has to be done right.
Right. All right. Well, we have just a little bit left. What's the next step? What happens next?
Well, last Friday, we delivered this letter to Judge Moore. We're waiting for her to respond to two of our requests to transfer and to restore Judge Newman. If that doesn't happen, there will be other steps taken. I think I'm going to not reveal our strategy just yet,
okay.
but we're not going to just say, okay, well, we asked, that's it.
All right, fine. That seems reasonable. We're walking away. All right. I think we're gonna be watching this case. I think I find it fascinating, and I've met Judge Newman, and obviously I think she's pretty on the ball myself. But I do think the issue is something that we're gonna have to.
Let me just add the last thing. Judge Newman is no different now than she was 40 years ago.
Welcome back to Administrative Static. Mark Chenoweth here with John Vecchione, and we are pleased to have with us in a return to Administrative Static, our colleague Russ Ryan, Senior Litigation Counsel here at NCLA. Welcome back to Administrative Static, Russ.
Thanks for having me. Always glad to be here.
Well, it seems like every time we have you, you're a thorn in the side of some government agency, Russ, and I'm pleased to say that appears to be the case again. Now, I've been following this issue a little bit. So the Securities and Exchange Commission has been investigating and targeting for potential prosecution a woman named Marian Young and her former investment business, Saving to Retire. And they've just been sitting on the case for a long time. Is that basically what's been happening?
Pretty much. The whole ordeal started in 2014, and Ms. Young and her firm were inspected by SEC inspectors. That then led to an investigation a year later. And the commission finally filed formal charges against her administratively in 2016.
So 7 years ago.
Yeah, and the charges were fairly benign. We should point that out. Essentially, she had this tiny investment advisor firm. She registered with the SEC as an internet advisor, which is permissible. But apparently her firm was so small that she didn't actually qualify for registration, and the SEC took offense at that. There were some bookkeeping violations too, and allegations of lack of cooperation with the investigation. But in any event, it went to an administrative law judge, I think in 2017. The administrative law judge ruled against her, not surprisingly.
As they always do, or almost always do.
She appealed to the SEC commissioners, which is the way you have to do it in the administrative process.
Right. You have to appeal to the commissioners before you can appeal then to a federal U.S. Court of Appeals.
Right. So while that appeal was pending before the commissioners, the whole Lucia case came down, which said that the SEC ALJs were not properly appointed.
Right, including the one who had heard her case,
Correct.
presumably. Yeah.
Correct. So she had to go back, and they could have just ended it there and said, no more,
Right. No mas.
Right. It's been going on long enough. It's not a really important case. But instead, like many of the other cases, they went back and sent it down for a new hearing before a new ALJ.
It seems like they get their teeth in somebody they don't want to let go.
Yeah, they don't like to. So the parties then said, well, we don't need we don't need another hearing. We'll all agree that the new ALJ can just read the hearing transcript and all the papers and decided anew. The second ALJ ruled against her again, but imposed much lighter sanctions, acknowledging that there was no fraud, there was no customer harm, there was none of the usual earmarks of a bad actor that deserves to be severely punished. But it was still enough for her to appeal again to the commissioners.
Looking for someone with some sense, some common sense here.
Right. So the ALJ
sense of proportion, maybe.
The second ALJ decision was issued in August 2019.
Okay, so we're still talking almost 4 years ago.
Correct. She appeals, all the briefings done in December of 2019. But the case has just sat there for now almost, I guess, 4 years since she appealed, or 4 years since the ALJ decision.
Yeah.
And the commission just keeps issuing every 90 days a perfunctory order that says, we need more time. We're going to give ourselves another 90 days.
I think you said there have been 11 of these now. So
11,
990 days that they've blown past the deadline.
Yes. And they do have their own internal rule. It's not binding. It's
not binding. It's not binding on them.
It's not binding on them.
Their internal rules are always binding on Marian Young.
But it says
she can't blow 990 days past the deadline.
But the SEC rules says that even in the most complicated cases, the SEC commissioners should decide appeals within no more than 10 months after the briefing closed. So that would have made it October 2020 should have been the last day they would need to get a decision out. But that's when they started issuing these 11 consecutive orders.
And maybe you give them a little leeway because COVID pandemic hit during that time, but not 11 extensions worth of leeway. Maybe one or two.
This is not the type of thing that should really be slowed down by working from home. It's a fixed record.
The second ALJ just did it from a fixed record. They ought to be able to do the appeal the same way.
U.S. Courts of Appeals have not slowed down getting opinions out within 6 months or so after oral argument and briefing.
Right.
So, and keep in mind, the SEC staff, I think, is still working from home, except for maybe one day a week. So if that's really an excuse for having slowed down their work, they must be at a snail's pace right now.
Given the traffic this morning, they must be the last ones working from home in downtown DC. Get in your cars and get back to work, SEC. So what are you doing about it, Russ? What's NCLA? What did Miss Young ask NCLA to do? What's been your approach here?
So she just finally got fed up and basically said, I need some closure on this case. Luckily, she's in the Fifth Circuit, so she should get the benefit of the Jarkessi case, which you've probably talked about on this program. But in any event, she just wants an answer. So
let me get on with my life.
So we filed in the Fifth Circuit because she lives in Texas, and the proper venue is the Court of Appeals, not for something like this, rather than the district court. And we're basically asking the Fifth Circuit to either tell the SEC to dismiss the case once and for all based on unreasonable delay and Jarkessi and so forth, or at a minimum, tell the SEC, you got to decide this case within, say, 30 days, or else we're going to tell you to dismiss it, because you can't just leave people sitting in limbo for years and years and years. I mean, the administrative
purgatory, if you will. Or...
Yeah, the Hotel California, if you will.
Right.
You can
say more about that, because
it came to mind early on that this is, you can check out mentally, but they won't let you leave. And so she's been stuck in it now for 7 or 8 years. And it's
the Hotel California comes to Texas.
Yeah. So that's what we're asking. We're asking
and this is a writ of mandamus.
Right. A writ of mandamus. Basically, the court would tell the SEC, get off the dime and dismiss this thing, or decide it so she can then take the normal appellate route and at least keep in mind, in all these 7 years, this is the first time she's ever been in court. She's
right.
So
yeah, 7 years of administrative process, not seen a real Article III judge during that entire 7-year time.
Nor a jury.
It was crazy. Yeah, right. Nor a jury. I mean, this is so inexcusable. It's utterly unbelievable to me that our administrative process does this to people over and over again.
And we point out in the petition, she's not alone. All the remaining cases post Lucia either fizzled out through settlements or defaults or what have you, but there's still a dozen or so on the docket.
There's that one case that went to the Supreme Court. It's on the tip of my tongue. Oh, that's right. Cochran, the one we just won against the SEC. That's right. Okay.
In fairness, I think we agreed to stay that case while it went through the courts.
All right.
But no, she's similarly situated, as are about a dozen other litigants who have all had their ALJ hearings. They've appealed to the commissioners. The appeals are fully briefed for at least a year or two now, and some of them 3 or 4 years. And the SEC is just, I think, willfully refusing to decide any of these cases.
And why is the $64,000 question?
I think there's a number of reasons. I think one of them is they know they've got Cochran, Jarkessi, all these cases percolating that are casting serious doubt on the legitimacy of the entire administrative adjudication system. Yeah. And they're paralyzed.
They had all these redos after Lucia. They don't want to have to do another set of redos after Cochran, another set of redos after Jarkessi, another set of redos after whatever other cases in the pipeline.
I think the last thing they want is letting litigants go to other federal courts to maybe get Jarkessi 2, Jarkessi 3, depending on what you want to call it. But one other reason they might be paralyzed.
Well, I want to call it Jarkessi, but that's just me.
Okay.
There does, I think, like amicus and amicus, this is a matter that has now spread throughout the law with different lawyers saying different things.
It's very true. Very true. Is there any other reason? I mean, is it laziness? Is it that the SEC commissioners don't? It doesn't seem like it would be that time consuming just to put these things to rest.
Yeah, this has been a problem for the SEC for years. But the other reason they may be paralyzed is, you might recall about a year ago, the SEC issued a public admission that there was a, quote, control deficiency.
Yeah. Where
files of the adjudicators were potentially available to the enforcement staff.
Yeah. The prosecutors were reading the judge's homework.
They've promised to investigate and release more information, but they haven't over the past year. But
they've said that they looked into it and it's all okay.
Yeah, they admitted publicly that it affected the Cochran and Jarkessi cases.
Yeah.
But they haven't, and they said it probably affected others, but they haven't said which ones.
Right.
It's not hard to imagine that all the pending cases around the time that Lucia and Cochran were pending were similarly tainted, including Marian Young's case and these other dozen. And so I think they're concerned that when all the dust settles on that control deficiency issue, they might have to redo all these proceedings.
Or dismiss them.
Yeah, or dismiss them. So they're just between a rock and a hard place, really. And this just goes back to about a decade ago.
Yeah. Well, and people like Marian Young shouldn't have to suffer as a result of the SEC's misbehavior here. Well, Russ, thank you for representing her, for filing this mandamus petition and for letting our administrative static audience know about it.
Thank you.